So here at Pondering Politics, one of the things that we've been trying to do is have interesting conversations with interesting people. And up there was Sheldon Whitehouse. This is one I've been trying to land for some time. So my next guest is Professor Leah Litman. She is a law professor at the University of Michigan Law School. She is the co-host of the Strict Scrutiny podcast. She is the author of a new book called Lawless about the conservative Supreme Court. And I think most of all, she is the Swiftie Solicitor General. She is the diehard defender of Taylor Swift. Professor Litman, how are you?
I'm doing well, especially now that Taylor owns all her art.
I just heard about that. I heard it. Well, let's talk about that first. We got to set our priorities. Let's start with Taylor Swift, the world's biggest pop star. She now owns her art, but the president of the United States says she's no longer hot. He's taking shots at her. What's up with this? Is Taylor Swift no longer hot, musically or otherwise?
Last I checked, she's still owning the Billboard charts. So I think this is another one of those alternative facts that the president is so famous for.
Yeah, I don't understand what the one-sided beef is. I mean, I know she endorsed President Biden in 2020 and Vice President Harris. I think that's it. You think that's just it? That's
yes.
The end of it? Yeah.
Yes. Well, also she's like a successful independent woman, which, is very threatening.
Well, to him and to Samuel Alito, as we'll discuss here in a few minutes. But, your love of Taylor Swift notwithstanding, which is something that comes up quite a bit in Strict Scrutiny, you have become a very vocal critic of this conservative Supreme Court, and I share. This is one of my theses here at Pondering Politics. I complain about the Supreme Court quite a bit, and you just wrote a book about it. So let's talk about Lawless. I just finished it. It is very, very good. It's very accessible. So I went to school for political science, but never to law school. So there's still a lot of legal jargon that I don't get. You have written an extremely accessible book with pop culture references. You quote, what's the one with Reese Witherspoon? I almost said House Bunny, but that's
Legally
not it.
Blonde.
Legally Blonde. Legally Blonde. You quote American Psycho in it with Patrick Bateman. So what prompted you to write the book and why release it now?
I think a combination of different reasons. One is I was very disturbed by what I saw at the Supreme Court when I clerked there almost 15 years ago. And so in some ways, this book has been many years in the making, as I don't think people appreciate just how powerful and in some ways dangerous the Supreme Court is to our democracy. And then more recently, it felt like the country kind of got a wake-up call about the Supreme Court when they overruled Roe versus Wade. But then gradually over the last few years, we've turned our attention away from the court. And I think that that's a huge problem. And so I wanted people who have this intuition or instinct that something isn't quite right with the Supreme Court to be armed with a ton of information, and for people who care to understand more about the relationship between the court, law, politics, and society.
Yeah, I mean, it definitely does that. I feel like, as concise as the book is, did you feel like while writing it, you could have written 3 more? Because you covered a lot of case law, but there are other things, like you could have talked about the Trump immunity decision more and other things. Did you feel like it's the part of a series about the Supreme Court?
So part of the difficulty with writing a book about the Supreme Court is they are constantly providing me with new content. And also there's just so much content to possibly work with. So yes, I could have written a book probably 10 times as long as this one to cover additional cases on law and religion, to cover the Second Amendment more, to do this, that, and so many other things. But I wanted to get this book out and draw what I think is an important through line across several different areas of law. And that's the extent to which the Republican-controlled court is drawing on the Republican Party's political talking points and laundering them into the language of the law, particularly with respect to this idea of conservative grievance.
So there's a lot to unpack there. I want to actually step back and kind of highlight a comment that you made just a few minutes ago, which is that, in the aftermath of the Dobbs decision, there was a lot of political backlash. That red wave became more of a pinkish trickle in 2022. And yet, as I said recently in a conversation I had with Senator Whitehouse, who's leading the charge in the Senate for judicial reform, it feels like we can never underestimate the American people's capacity to get used to anything. So after Dobbs, we were all pissed. Everybody was pissed. Women, men, everybody in this country about, well, at least liberal and progressive people in this country, about taking such a fundamental right away from women. And now it seems like we've just gotten used to it and all right. I mean, I guess it'll be a state-by-state basis. Have you noticed that as well, that we've become used to it?
It's one of the things that is most terrifying and frustrating. And it was also one of the things I was most agitated about in the lead up to them overruling Roe, because it felt like in that time we were being told, or at least some number of women were being told by men, particularly men on the left, that, oh, overruling Roe was going to be this gift to the Democratic Party and help them win elections from here to eternity. That was never going to be correct. And it has proven to be wildly false, since in the first presidential election after the court overruled Roe, the party that appointed the justices who overruled Roe prevailed in the presidency and in Congress. And I think the other really horrifying thing is we have already had multiple stories about women who have lost their lives because of abortion restrictions. A single story about a woman who died because of an abortion ban in Ireland precipitated massive liberalization in that country's abortion laws. That has not happened in this country. Instead, these stories have just continued and fallen out of the news because they are just old news at this point.
Yeah, it really is tragic. And I mean, it's one of those things. It's like, even people who engage in political commentary, like in my space, it's hard to keep track of. Like, who knows how many people? We saw some high profile examples during the election, particularly one case out of Texas. Her first name is Amanda, and I'm blanking on her last name.
Zorowski.
Yeah, and it's, how many others have been like that with these trigger laws going into effect, where Republicans have been salivating over this decision. And when I talked to Senator Whitehouse, I asked him, I think it was after the election was the most recent conversation we had, and I said, do you think that the Democrats should have made Supreme Court reform a higher profile before the election? Because, as I know you're aware, the polling favored it. Like, there was an appetite for serious changes, term limits, expanding the court, et cetera, and so forth. And Senator Whitehouse said, yeah, he wishes there were, and he's concerned that we missed the boat on that. Do you share that concern as well, that we missed the moment?
I do think we missed the moment. There was this moment where people, again, were focused on the court and understood how problematic the court is. And now the court is getting a ton of free PR. And I think an unjustified boost from the handful of occasions when they rule against Donald Trump in some cases, even though they laid the groundwork for the Trump presidency, even though they are giving him a lot of what he wants. And I am concerned that the Democratic Party is once again falling by the wayside in not learning how to talk to their voters, the country, their base about the Supreme Court and what it's doing.
Yeah, one of the things, like I said, that I complain about a lot is this idea that the Supreme Court is this apolitical body. You make the case very compellingly in your book. I would argue it's the thesis of it, that it is a very political body. I would also argue it has been from the inception. I mean, the founding fathers changed the composition of the Supreme Court, President Adams, President Jefferson, based on purely partisan politics. So is it your contention that the Supreme Court was once apolitical, or no, it was always political, it just operated under a veneer of apoliticization until recently?
I think it's always been political, but what I think has changed is a few things. One is the court is way more powerful today than it was, particularly at the founding. Two, the rise in partisan polarization has allowed parties to appoint justices who more reliably track the party's views on a range of issues, whereas before presidents were really focused on maybe one issue, maybe two issues, and they could find people who they thought would rule on those issues in particular ways. Now it's so much easier to find someone who tracks their views on basically any issue that might come before the court in a high profile or ideologically salient way. And then the third thing is the extent to which certain issues that, to my mind, are essential to a modern liberal constitutional democracy have become polarized, like the issue of voting rights or whether the president is above the law. Those are not things that can or should be split along partisan lines. And when you have the Supreme Court basically enabling an autocratic takeover of a liberal constitutional democracy, like that is its own kind of political lawlessness.
Yeah, you said so many things that are worth unpacking. I want to talk about the power of the court in a moment, because this is the subject of a long-standing debate that I have with a fellow podcast co-host who has me at a disadvantage because he is a lawyer. So he defends the Supreme Court as an institution, even though he's very critical of it in its current iteration. But let's talk about the Trump immunity decision for a second. So, this is your profession. You teach constitutional law. You have litigated, I believe, in front of the Supreme Court, if I'm not mistaken, at least like 3 times I saw when I was looking at your biography. My question is, did the Trump immunity decision surprise you? Because I know people, I was not surprised, but I'm a cynic. I know people who are liberal and progressive who are like, dude, there's no way. There's no way in hell. Because what if a Democrat What if like President AOC, gets into power? Do they really want to give a President AOC that sort of immunity? Were you surprised?
I was not surprised. I think their decision to take the case and the timeline on which they took the case basically showed their hand that they were going to give Donald Trump a huge win. I didn't know exactly what that immunity would look like or how they were going to write it, but I wasn't surprised that they did rule for him.
Some people who were surprised too said, okay, well, I expected that they would drag it out to politically benefit him, but that when push came to shove, they would say, of course not. The only immunity that the Constitution confers is the speech and debate clause in Article 1. Do you think that it was as sweeping immunity as they could have given? Like, I've seen constitutional law scholars say that this was actually worst case scenario.
Yeah. No, I think that's right. It is difficult to imagine a broader ruling in favor of Donald Trump. And part of the reason why I wasn't surprised is the Republican justices have been all in on presidential power and really fringe theories of presidential power for the better part of 3 decades at this point. As I write about in the book, John Roberts, when he was a lawyer in the Reagan administration, he was pushing this unitary executive theory, which he partially wrote into the pages of the U.S. reports in that immunity ruling.
Does unitary executive theory again apply to Democratic presidents,
Nope.
or is it like
no? Think about it this way. Okay, so the Supreme Court said Joe Biden could not exercise the authority given to him by Congress to cancel student debt, but Donald Trump could violate restrictions on presidential power that Congress had enacted when they tried to limit his ability to fire members of the NLRB or the Merit Service Protection Board. So, yeah, no, there is zero consistency or neutral principles at work here.
Yeah, it's very much the sort of tortured logic that you provide examples of and demonstrate in the book that you point out. Yeah, it was definitely a catastrophic decision. The one decision that surprised me recently, though, and you reference it in the book, was Moore v. Harper. I'll be honest with you, I expected them to lean full bore into independent state legislature doctrine. Did that decision surprise you? Because at least on its face, they were like, nah, this is a bit too extreme.
So no, for 2 reasons. One is the version of the independent state legislature theory that was being pushed in that case was not the version that the Republican justices had really signaled some openness to. So the theory that was being pushed in Moore versus Harper was basically state courts can't enforce state constitutions against state laws dealing with the election, or at least can't enforce substantive state constitutional protections. None of the Republican appointees had gone that far by that point. And then second is the case offered them the opportunity to do something John Roberts loves to do, which is give a superficial win for progressives or the left. So it gets tallied as, oh, the Supreme Court is ruling against Republicans, when actually he smuggles into the opinion some time bomb that will go off later. So in that case, they rejected the version of the independent state legislature theory that was being pushed, but into the opinion ruling against that extreme version of the independent state legislature theory, they reserved the possibility of engaging with another version of the theory, specifically the version of it that had appeared in Bush versus Gore, the infamous decision that stopped the presidential count in 2000 and awarded the presidency to George Bush. And so if that's the version that they are saying we are going to make the law one day, I'm not willing to count that as some big moderate institutionalist win.
This makes me feel better because a lot of people criticize me for being a cynic, but I'm just going to refer to you. I'm going to Professor Litman is also not very optimistic about the current state of the court. You mentioned earlier that the court has become increasingly powerful. So this is where, and if I get this wrong, you correct me, but this is my interpretation as somebody who's observed the court and somebody who's studied political science, which is, the framers intended for the Supreme Court to be the weakest of the 3 branches. They were very clear about that in the Federalist Papers and the constitutional debates. I would argue in some ways it has become the most powerful of the branches in the sense that it can strike down executive orders, it can strike down federal statutes. Now, obviously, you need the president to acquiesce and enforce those things, but non-acquiescence, I'm told, is unconstitutional. So the president is obligated, at least on paper, to do whatever the court says. So how is the Supreme Court simultaneously the weakest of the branches if it's also the one branch that can tell Congress and the president what to do? Because we saw a lot of that during the Biden administration.
Yeah, I mean, there's no question that the court's powers have evolved considerably since the founding. The Supreme Court had to say that it had the power to declare unconstitutional federal laws. That wasn't something that was necessarily settled or everyone agreed on. The Supreme Court also had to give themselves the power to review decisions of state Supreme Courts. People at the time didn't necessarily think the United States Supreme Court had that power. So, through a series of decisions, the court has accumulated more and more power. Some of that power is because Congress gave them the authority to decide what kind of cases they would hear, for example. But some of that is authority they gave to themselves, like the power to decide what issues in the case they were going to resolve. So, in the big Citizens United case, for example, where the court started demolishing campaign finance regulation, initially, that case wasn't about whether the court should strike down the federal law restricting corporations from advocating for or against certain candidates, but the Supreme Court decided we would like to answer that question. So they just did. And I think we are now in this position where the court both has a lot of power, but also its power is precarious in certain ways. Their authority depends on the public buying into the court and seeing the court as legitimate, and the political branches respecting the court's judgment. And I think all of those things have been jeopardized for different reasons. Some is of the court's own making. They have reached such partisan, hackish decisions that their approval ratings have dropped. The president is an autocrat, and so he doesn't believe in the legitimacy of any law that might constrain him. So I think for a variety of reasons, the court now finds itself in this situation where it has claimed all of these powers, but it's a little bit of a shell game in certain ways.
The frustrating thing on top of it is, like, as somebody who believes in democracy and even Republican government, I'm just allergic to the notion of the unelected branch being the most powerful. But even that concept, I could wrap my head around or more easily swallow if there were binding codes of conduct, if there were consequences, if there was a recusal process worth a damn. It seems to me it's like the one branch that's claiming the most power is also claiming simultaneously it should be held the least accountable. Do you see any, I guess, moving on that front? Because some will say, well, Professor Litman, Justice Roberts finally folded. He published a code of conduct. He put it to paper. What more do you want from him?
That's another PR move. He released this non-binding statements of ethics guidance. There's no enforcement mechanism. Also, the principles that the justices adopted, not all of them even abide by them. So the justices are supposed to explain why they are recusing themselves. Guess what? The Republican appointees don't always do that. Don't ever do it in some cases. So I think that is another example of John Roberts being a very savvy politician and generating a lot of favorable press coverage without actually doing anything substantively to reform the institution or make it more legitimate. I do hold out hope that this is one of those issues where there could be rather quick political movement, because it's one of those issues where there's just supermajority popular support for, of course, the justices shouldn't be able to accept an unlimited amount of largesse and gifts from people who have business before the Supreme Court. That's just common sense.
Can you imagine, Professor, if it were Justice Jackson that received millions of dollars of undisclosed gifts? I mean, I'm just, I tried to train myself not to get frustrated with the hypocrisy, but it's really challenging, because we know Supreme Court ethics would pass in a fucking heartbeat if it were a liberal majority and it were Jackson or Kagan or Sotomayor. And yet the Republicans in Congress, who probably know on some level, like, yeah, this is super screwed up, but because they reliably deliver the outcomes the Republicans want, if it ain't broke, don't fix it in their mind. So do you think any Supreme Court reform will ever happen with Republicans in power?
No, as long as the court is giving them what they want, they are fine with the strategy of by any means necessary. And we know they would freak out if the shoe was on the other foot. If you recall, a few years ago, there was a story about how Justice Sotomayor was purportedly having dinner with Chuck Schumer, and the right-wing media ecosystem lost their mind, only it turned out Chuck Schumer was having dinner with his wife. And so, yeah.
Speaking of troublesome wives and marriages, again, your book addresses right off the bat Justice Alito and Mrs. Alito and the flag situation. It's in terms of like recent Supreme Court scandals, what shocked you more? The flag situation, the undisclosed gifts, what really like stood out to you as kind of surprising?
I think in some ways, the most shocking thing for me was to read the text messages that Ginny Thomas had been sending to state lawmakers, because it's not just that she was involved in politics. It's not just that she was involved in the effort to overturn the results of the 2020 presidential election. It's that it's clear at least one member of that household has bought into the most unhinged conspiracy theories you can imagine. I mean, she was sharing and writing some things about how, quote, the Biden crime family should be held on barges and tried for crimes at Guantanamo Bay. I mean, truly nutso stuff that I think just gives a small window into how this is a court that is captured by far right conspiracy theories.
Yeah, well, again, your book goes into vivid detail about that. You end, again, I'm thinking of the conclusion chapter there, where you talk about, okay, listen, I don't mean to come off so pessimist, and you give a list of things that, could be done to at least salvage the integrity of the court. And you're very clear to say this by itself will not work. This by itself will not work. In terms of all the proffered reforms, do you endorse all of them? Term limits, court expansion. What would you like to see with a Democratic trifecta?
Yeah, so term limits, court expansion, limiting the court's authority, both over their own docket and their ability to strike down laws like the Voting Rights Act or a federal law that codifies abortion restrictions, ethics reform. I mean, again, I think the court is so damaged. We cannot just allow it to fester and get worse. I mean, think about just so we're recording this on Monday, June 2nd. Just today, the court agreed to hear a case about whether a Republican lawmaker can challenge a law that allows a state to count ballots that are received after Election Day. That could potentially open the door for courts to end states' ability to count ballots received after Election Day. And it's that type of interference with the democratic process and our democracy that I think underscores how serious a problem the Supreme Court has become and why we need to do something about it.
Would you agree, I guess, in conclusion on that? Like my posture is that Trump and MAGA are the immediate political threat, but that the Supreme Court in its own way is as dangerous. It's just kind of a more looming threat in the background. Do you think that that's about accurate?
Yeah, I mean, no question that the biggest danger right now is Article 2. The problem is that Article 3 is very much on board with a lot of what Article 2 is doing and will be able to do some things that Donald Trump won't be able to once a Democrat is in office again.
So two last questions for you. This is the last serious question. I'm curious what you thought about this recent development where Donald Trump publicly attacked Leonard Leo. I was of two minds about it. I'm like, hell yeah. It's like,
let them fight.
Exactly,
let them fight.
Exactly. But it's on the other hand, his beef with Leonard Leo is, damn, Leonard, you gave me some judges that will occasionally rule against me. So I don't know. When I did a video about this, I'm like, I'm not entirely optimistic. I'm enjoying the fighting, but I don't know if a purely Trump-selected list of judges would be any better. How do you feel about this development?
Oh, it's not going to be any better. But I think this development is buying the Federalist Society and Leonard Leo with some good press coverage and depicting them as so reasonable compared to the sort of loyalist, lawless hacks that Donald Trump is certain to also nominate to the federal bench. But the reality is, in the first Trump administration, and also I think during the second, there's still going to be some confluence between the Federalist Society and loyalist, lawless hacks. Think about, Matthew Kazmarek, one of the judges who was appointed during the first Trump administration, who ordered the nationwide ban on medication abortion and has done a billion other cray-cray things. So I don't. Well,
Professor Litman, I'm sorry. I hear a lot of Republicans say that they don't support nationwide injunctions or forum shopping. Okay.
Slight footnote, unless the nationwide injunctions are issued by Texas or in Texas. Turns out that's the exception to the rule. But yeah, I mean, it's just like this fight is just the latest encapsulation of any deal you make with Donald Trump. You know, you're going to get dragged through the mud and thrown by the wayside because this is someone who only cares about his own power and loyalty. And the fact that people, organizations, institutions were willing to make a deal because they thought they could get something out of it speaks extremely poorly of them. And the fact that they, again, continued to support him throughout his first 4 years and didn't distance themselves from him during the 2024 election. I mean, they bear a lot of responsibility for what is happening. And I still don't think we are going to see this sharp absolute departure where Donald Trump isn't appointing anyone who's affiliated with the Federalist Society. He's still going to, because that pool also offers him a bunch of partisan hacks.
Yeah, I mean, I would say in aggregate, there's no question that the Federalist Society has been good to Donald Trump and vice versa, even though he's pissed off at him right now. In terms of the book, and you're doing interviews for it, I don't know if you're like going to book signings or whatever. So in terms of what you're doing right now, law school and teaching notwithstanding, what's up for the book and what's going on with strict scrutiny? And then I've got a Taylor Swift related question for you. But what's coming down the pike?
Yeah, so strict scrutiny, we've still got our weekly episodes coming out with additional bonus episodes anytime the Supreme Court releases an opinion in an especially big case, which sometimes happens, throughout the month of June. So available anywhere you get your podcasts. We're also on YouTube. Just look up strict scrutiny. The book Lawless, the full title is Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. You can get it anywhere you get your books now. If you like getting your books online, you can get it at bookshop.org. Which is an online retailer that supports local independent bookstores. There aren't a ton of book events. I do most of this kind of remotely, but I will be, through the podcast, we're doing a live show in New York City in June and then one in Chicago in October. So those are the in-person events right now. But again, if you want to hear more about this, I read the audiobook, and you can also pick up the book wherever you get your books.
That's awesome. Yeah, I got mine. I got a digital copy of mine, made annotations with a highlighter in it. It was freaking awesome. And I'm looking for it. I'm hoping that eventually there's a sequel because I feel like after 4 years of Trump, you're going to have much more to write about as well.
Oh, yeah.
So Taylor Swift related question.
Okay.
You're exiled to some sort of island. You have an iPad without internet. And I know you're giving that expression because under the Supreme Court, it's entirely possible that happens.
They are going to exile me to an island.
as an outspoken woman critic of the Supreme Court, that's possible, unfortunately. But you're exiled to an island. You're given an iPad with one song option. Okay. What Taylor Swift song will you listen for the rest of your exile?
Can I give 3 options because it will depend what day I'm exiled to the island, if that makes sense?
Go ahead.
Okay, so I think the majority of days I would pick All Too Well 10-minute version. Fallback would be Would've, Could've, Should've, one of the vault tracks from Midnight. And another possibility is Hits Different, another vault track from Midnight. I think those are the 3 most likely choices.
That's fair. I'm going to throw an old one at you. It's about 10 years old now. The titular track on Red. So.
Oh, yeah. I love that song. Absolutely love it. I mean, while we're throwing out other possibilities, Cornelia Street, Maroon, Exile, you name it, Ivy, 'Tis a Damn Season. So many great options.
So you are a big fan of the deep cuts as well. Is she going to be re-recording the entire back catalog, or now that she has the rights, she no longer has to do that?
So she said she has already recorded Debut, but she has not finished re-recording Reputation. And it's not clear exactly when she will finish that. She did say at a minimum, at some point, she would release the vault tracks, the songs that she wrote during Reputation, but that weren't included on the Reputation album. So I'm holding out hope, waiting for those.
That would be awesome. I became a big fan of hers. This might be a strange one, but she did a CMT crossover event back in 2008 with Def Leppard, and they're my second favorite band, and it was phenomenal. So, but Professor Litman, I really appreciate your time. I'm a huge fan of Strict Scrutiny. I love the book. I appreciate your advocacy on this and how you have not been cowed as many others in the Trump administration have been. You continue to speak out, and hopefully you are not sent to the gulag under this administration. But thank you so much for your time, and I'm looking forward to chatting with you in the future, I hope.
Thanks for having me.